Once again, good afternoon, Judge Molemela.
Good afternoon, Acting CJ.
Welcome to this session of interviews.
Thank you.
As you know, it's being held because the court said we must have a fresh interview. So thank you for making yourself available once again.
It's a pleasure, CJ.
I see that you have quite a number of degrees here. You got your BA degree at the University of Fort Hare, is that right?
Correct, CJ.
And as well as the BProp degree.
Yes, that's right. That's right, yes.
Yes. And then you got your LLB
Yes,
at the Free State University.
that's right.
And then you got your LLM
That's correct.
at the Free State University. And you were admitted as an attorney and practiced for about 10 or 12 years?
12, CJ.
12, yes. And you were appointed as a judge in 2008 after you had acted for some time.
Yes, CJ. I think if my calculation is correct, it's 15 years.
Of practice?
That's right.
Oh, yes.
Yes.
Okay. You were appointed in 2008 as a judge of the High Court, is that correct?
Correct, CJ.
And that means you have been on the bench for about how long? About 15 years?
If you
From 2008?
From 2008 it will be 13, but if you include the acting appointment, it's 14.
Yes, okay. And you were subsequently appointed as Judge President of the Free State High Court.
That's right.
And how long did you serve as Judge President of the Free State High Court?
For 3 years.
Yes. And during that time, you also got an opportunity to act in the Constitutional Court, is that right?
That is correct, CJ.
Was that 2015?
That was 2015, that's right.
Yes. And was it for 2 terms?
It was for 2 terms, yes.
Yes. And I see that you have also acted in the Labor Appeal Court and in the Competition Appeal Court.
That's right. And I ended up being appointed. I acted from 2011 at the Labor Appeal Court and got appointed there in 2014.
Yes. And then how long did you remain there before you were appointed to the Supreme Court of Appeal?
Remain there as...
In the LAC?
No. I was never at the LAC, and I think I need to explain because it seems sometimes people don't understand. So when you are appointed as an acting judge of the Competition Appeal Court or of the Labor Appeal Court, you don't really have to leave your division. Let me start with the Competition Appeal Court. The cases are accommodated within the court term of the High Court, meaning that you will be excused only for the days on which you will be sitting in the Competition Appeal Court. Say now, if your matter is going to be heard over 2 days, it means you'll miss 2 days from the division.
Yes, but I thought you said you were appointed, because even though it might work like that, it's different when you are acting and when you have been appointed.
Yes.
As a judge of appeal in the Labor Appeal Court.
Yes.
Were you appointed as a judge of appeal in the Labor Appeal Court?
That's right, yes.
Yes. Yeah, because
while I was still serving as a judge of the High Court, that's right, yes.
Yeah, you didn't physically leave
No.
the High Court, but
That's right.
you were not acting in the Labor Appeal Court. You
That's
were found
right.
to be fit to be appointed.
That's correct.
Yes. And but how long was the period that you were a judge of appeal in the Labor Appeal Court before you were appointed to the SCA?
4 years. Sorry, yes, 4 years.
Yes. So you would sit as and when you were required in the Labor Appeal Court.
That's correct, decision.
And in the Competition Appeal Court, were you appointed as a judge of that court, or you
No.
were only acting there?
I only acted. I acted there for 2 years, but like I explained, it would mean I would go to Cape Town only for the hearings and then come back to the division and continue with the work in the division.
Yes. So you have experience in the High Court, you have experience in the Labour Appeal Court, you have experience in the Competition Appeal Court, and you have experience in the Supreme Court of Appeal.
That is correct, DCJ.
Yes. And how did you find the work in the Supreme Court of Appeal after you had been appointed there?
I enjoyed the work very much, DCJ. Intellectually challenging, but I coped. I
Yes.
think I managed to cope quite easily with the workload because having been a judge president at the Free State High Court, I had to do both management of the court and the other courts, the lower courts, about, I think, 70 or 80 lower courts that are, fell within the jurisdiction of the High Court, and that I remotely had to manage in addition to running the division. And in addition to that, I also had to do the work itself in terms of going to court and so on. But then as a judge president, you have to lead from the front, which means that when complex cases were on our roll, I would make sure that I participate on them. Some of the cases, we would do them as a full bench, meaning it would be me and 2 other judges, and others I would be the sole judge. And in circumstances where I was not involved in that particular case, I would, in any event, make sure that I familiarize myself with the issues, because sometimes it happens that a matter has been set down and a colleague gets sick. And so I was always on standby to do the work. So I always did extra reading in addition to what was on my own plate. I would also read other matters just to be in a standby position. And so I found that when I got to the Supreme Court of Appeal, I was able to manage. The workload there is quite hectic, but I managed easily to do the work. Yeah, so I would say that the jurisprudential leadership that I brought from the High Court, having been the judge president, assisted me. And when I got to the SCA, I managed to flourish. I managed to write not only judgments where we were unanimous. I also wrote dissenting judgments, and 4 of those dissenting judgments that I wrote at the SCA were confirmed by the Constitutional Court. And I would also add that, having acted at the Constitutional Court assisted me also in terms of the performance of my work at the Supreme Court.
When you were judge president in the Free State High Court, what was the complement of judges in your division?
I think 16, if I'm not mistaken.
16?
It might be, 16, I think.
Yes. And while you were in the High Court, were you able to write some reportable judgments as well?
Yes, as a matter of fact, there's a judgment that I wrote at the High Court, and the parties did not appeal against the judgment. I'm not sure whether they did not appeal or whether they tried going to the Constitutional Court and they were denied leave there. But the matter was concluded at the High Court. And years later, a matter similar to that one was heard by the Constitutional Court. And the Constitutional Court, in a judgment authored by Justice Petse, made several references to several paragraphs of my judgment. In other words, that judgment was also confirmed by the Constitutional Court, and in that way contributed to the jurisprudence.
Do you have a recollection of more or less how many reportable judgments you were able to write while you were in the High Court?
I'm not. No.
You are not able to.
No.
And in the Supreme Court of Appeal?
I'm sorry, I didn't count DCJ, but I think
There are
when
too
I
many.
read, it doesn't matter. Okay, when I read the report from the General Counsel of the Bar, I think they talked about 12 matters, and they said I was involved in 84 other matters. It's actually more than that. Yes.
And how was your experience of acting in the Constitutional Court in 2015?
It was a very enriching experience, DCJ. I enjoyed that stint. I found the workload quite challenging at the time, but I managed to do everything that was on my plate. And in addition to doing the work, I also managed to do a prison visit and, even compiled the report in respect of that prison visit, and it was published before I left. Meaning, in addition to the workload that I was doing there, I also managed to accommodate something extra because Justice Cameron was always at our conferences at the Constitutional Court, encouraging colleagues to do prison visits. So even though the work was challenging, I enjoyed it very much. I found it fulfilling, and I left that court a new person. And I have always maintained, and I think I've said this at this platform previously, that, when you act, it's not only a matter of yourself, the person who's acting, getting personal growth, but wherever you are coming from, be it the magistracy, be it the bar, be it the High Court in my instance, everybody benefits. Because when you go back, you are not the same person. You go back with a level of expertise, and colleagues, approach you to say, for some guidance in respect of their matters. And so the whole division benefited from my acting appointment. So not only did I benefit, but the whole division benefited from that.
Yes. And I'm sure when you were acting in the Constitutional Court, you dealt with a lot of matters where applications for direct appeals were made. What sort of factors were taken into account in deciding whether to grant direct leave for direct appeals?
The interests of justice, and whether there are any exceptional circumstances that warrant hearing the matter, meaning that you would have to exercise a discretion. And as to whether you would grant it or not would depend on the contents of the application that's served before you.
And did you get a chance to write judgments where you declared legislation unconstitutional and granted appropriate relief?
That is correct, DCJ, in the matter of Provincial Minister versus Oates Warren.
Yes.
Yes.
And in that case, did you have to deal with Section 36 justification exercise?
No, I didn't have to deal with that. In that matter, DCJ, the parties actually were agreed that there was a loophole in the section. The minister had initially opposed. The municipality had initially opposed the matter, but later on there was some sort of, let me call it in quotes, settlement, in the sense that the minister agreed that he was no longer going to ask for that order, in terms of which all the actions that had been done in terms of the resolution that was, the flawed resolution that was taken, would be set aside. And as soon as there was an agreement in that regard, both parties were agreed that the legislation was flawed, and that particular provision had to be supplemented. And it had to be supplemented by way of a reading in. But even though the parties had agreed, you'll see in the judgment that we still investigated that whether there was a need to do that, because we are always careful of treading into the sphere of another arm of state.
Well, you would have been involved, even if you didn't write the judgment, you would have been involved in judgments written by other colleagues where the Section 36 justification exercise would be done.
Yes.
So you were involved in such matters.
Yes, DCJ.
Yes. Okay, thank you. Commissioners. Commissioner Nyambi.
Thank you, Acting Chief Justice. Afternoon, Judge Molemela. I must say I'm impressed about the detailed CV. Somebody has been a prosecutor, candidate attorney, director, Molemela and Partners, commissioner of the CCMA, judge in the in Free State, and a judge president, and now a judge in the CA. So with that experience, I will ask just one question. Judge Molemela, if you can share with us some of the stereotype you have had to deal with as a woman judge and how you have managed to stay focused, professional and competent given the current, the historical and current challenges still experienced by women in our country.
Excuse, just for clarification, does that include before I was appointed as a judge?
Yes.
Oh, okay. Yes. Yes. I did, like so many other women, experience those challenges where, as a candidate attorney, I had to do certain kind of work. And my principals specialized in criminal law. But in terms of the consultations with the clients, I would be the first port of call, and I would have to take the client's statement. And I remember that on many occasions, the clients would say, but you are a woman. Are you sure you can do what a man can do? And I said, yes, I'm qualified. But there were those stereotypes, and some actually would tell you point blank, I do not feel confident being represented by a woman. So, and I now, with the benefit of hindsight, I know that that is the one challenge that has been a hurdle in the careers of many women, where you found yourself channeled to a particular field of law, which is regarded as soft law. For example, maintenance matters, divorces and so forth. And as a result, many women were not able to get exposure in commercial law and so forth. And at the end of the day, that is also what is responsible for the situation that we have had over many years, where the judiciary was not representative in terms of gender, simply because the pool from which female judges could be appointed was very small because of lack of exposure. The situation is being addressed. At some quarters, it has been addressed. But I must say that once I was appointed as a judge, I can't really say, I would not be telling the truth if I would say that I was discriminated against purely because of my gender. That has never happened. Where there were disagreements, it was not purely because of my gender. It was just disagreements as you would disagree with your brother or your sister, your mother, or your spouse.
Thanks, Judge Molemela. Thanks, Acting Chief Justice.
Thank you, Commissioner. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Judge Molemela.
Good afternoon, Commissioner.
You have had the experience of being a puisne judge as well as a leader of the division, and you have acted in specialist courts, in the LAC and the CA Competition Appeals Court, as well as in the SCA. You've acted also in the Constitutional Court. Tick all the boxes. Ideally, one would think that in a country like ours, with the mind that we have in people like you charting the way in the legal field, we would not be having so many appeals in the court systems, in the hierarchy of courts, because the law is or should be known. Now, as a judge in the apex court, like the Constitutional Court, is a judge that lays down precedent and rules for the courts below it. Now, how can one be assured that the Constitutional Court retains its precedent-setting authority, with the result that there is no doubt and there is no litigation that goes up back to the Constitutional Court on almost the same issues, or even, if I may suggest, why are we not having a limitation of number of appeals when we have a court of authority like the Constitutional Court? Will you be able to give your views about that?
Yes. Sometimes people will do things because they are allowed to do those things. There was a stage when the jurisdiction of the Constitutional Court was limited only to constitutional matters. And I don't think the workload was hectic at that stage. And then there were several consultations were held, and then it was decided to open it up. And when its jurisdiction was opened up, it was opened up to include matters where arguable points of law were being raised and they were found to be in the public interest. And once that happened, then things changed because more and more people felt that they deserved to approach the highest court and for their matters to be finalized there. So even in instances where the jurisprudence is really clear-cut, you will find people applying for leave to appeal at the Constitutional Court, and the application in most instances will be dismissed, but they will try. So in answering you, I will say the fact that that court is being buffeted by application is not because the jurisprudence is not clear-cut. It's because we have many, many cases coming from all the courts, and sometimes litigants insist. And even if you as a representative say, I don't think we are going to succeed there, then they terminate your mandate and go to the next one who will agree to go there.
Thank you, Commissioner. Then Commissioner Dodovu.
Thank you very much. Deputy Chief Justice, good afternoon, Justice.
Good afternoon, Commissioner.
Do you subscribe to the philosophy of judicial activism? Do you think that we need that in the context of the challenges that are facing us as a country?
Thank you, Commissioner. I would say there is sometimes scope for judicial activism, but generally one must shy away from it, respecting the separation of powers, which is what the Constitutional Court has been doing in many, many cases. And, given how liberal, our constitution, the South African Constitution is one of the most liberal constitutions that you can find anywhere in the world. And because of that, there's very little need to resort to judicial activism, because everything that needs to be done in terms of judicial activism is already contained in the Constitution. Let me make an example. The Constitution has several values, and one of them is social justice. Pre-Constitution, those who were resorting to judicial activism were doing so in order to achieve social justice, in order to achieve equity. Let me make this example with the judgment of Justice Schreiner in that matter, the Collins case, the 1957 case. At that stage, our country was a country in which the Parliament was the most supreme body. In other words, courts did not have the leeway to test the constitutionality of legislation. And in his dissenting judgment, Justice Schreiner found a way of deciding against the particular piece of legislation that was intended to exclude colored people from the voters' roll. In other words, despite parliamentary sovereignty, he found a scope to decide against that. And that you would call judicial activism. It was good because at that time, the system that we were under was the apartheid system. There was no justice, there was no equity, there were no human rights that were being observed. But in the context of the Constitution that we have today, that allows you to take social justice into account, to take into account substantive equality when you make your decisions, there's very, very little scope. But the one example that I want to make where I personally resorted to some form of judicial activism was in one of the cases that have been included, attached to the questionnaire, where a student had not relied on the Constitution in bringing her matter to the High Court and eventually to the Supreme Court. So you could put it this way, that no constitutional rights were implicated, and the student lost the litigation. And the matter came before the Supreme Court of Appeal, and there was really no merit in terms of the substance of the application, and the matter had to be dismissed. But even after dismissing the matter, I found that despite the fact that no constitutional issues had been raised, because of the nature of the litigation that had issues that had to deal with access to education, the student did not have to be ordered to pay the cost of the litigation. That was my view at that time. But the majority view was that because the student in question had not relied on the Constitution, no constitutional issues had been raised, and therefore there was no need to apply the BioWatch principle.
If I may take this point further, sorry, excuse me, CJ.
Yes.
If you don't subscribe to judicial activism, the truth of the matter is that 27 years since the advent of our new democratic dispensation, the poor and the marginalized still don't have access to court in a way that is equitable, equality, and all of that. And all the issues that you raise, whether it's equity, whether it's social justice, there are still problems obtained. And the poor, in terms of their financial position, they cannot do anything. If you argue that this is judicial activism is not one of the panacea to resolve all those questions, what is it that in precision can be done to attend to this situation that I painted?
Oh, okay. If maybe I may just go back, I did say that there are instances where it is justified. So there are instances where judicial activism is justified, and the example that I have just given is one particular matter. But there are instances where it is not justified because of the nature of the issues that have been raised. And in the case of Prince, Sachs J in that matter cautioned the courts to be very careful in relation to separation of powers, to say, if you are hard up, he didn't use those words. He said actually, judicial adventurism can be just as bad as judicial timidity, meaning that from my point of view, there's a balance. So it will depend on the nature of the issues that are raised in your case. Where there is scope to resort to judicial activism, you can do that. In many, many cases, you don't have to even do that because the Constitution itself permits you to do that. And an example would be, for example, affirmative action. The Constitution permits you to do it. So if you are going to find that the methods that have been resorted to in order to address the injustices of the past are sufficient and there's nothing wrong with them, you don't have to resort to judicial activism in order to come to that conclusion. You rely on the very Constitution for that
All right.
conclusion.
No, thank you very much. Thank you, Deputy Decision.
Thank you, Commissioner. Commissioner Shabangumdawe.
Thank you, ACJ. Good afternoon, Justice.
Good afternoon, Commissioner.
How are you?
I'm fine, thanks.
Thank
Trying.
Justice, in one of your, I think it's number 18, the question was asked to say, what would you regard as your most significant contribution to the law and the pursuit of justice in South Africa? There you mention your involvement with the members of the public, mainly in rural areas, who were advocating.
Sorry, Commissioner. I think Commissioner Mpofu is struggling to hear you. Maybe bring your mic closer and maybe raise your voice a bit.
Okay. Do you want me to start? Okay. Okay, for the benefit of Commissioner Mpofu, I will start. I think it's question number 18 on the questionnaire, where it says, what would you regard as your most significant contribution to the law and the pursuit of the justice in South Africa? You mentioned your participation with members of the public, mainly in rural areas. These people were advocating for the development of rural communities. This item, it's one of the items which is very close to the heart of many people in South Africa, specifically those who are staying in the rural communities. According to your assessment, has there been any change in this matter? Or where are we with the development of rural communities?
Strides have been made, and yes, there are changes, but I would not be honest if I were to say to you, South Africa remains an unequal society. And that this is the case is evident from many, many judgments, not only of the Constitutional Court, but the judgments from other courts, Supreme Court of Appeal, the High Court, and so forth. I was in an appeal recently which had to do with accommodation of farm workers. And as I was reading the authorities that we were referred to, I came across a judgment of Justice Sachs of 2000 and I think it's a 2004 judgment, PE municipality. And there he laments how unequal a society South Africa is. And he in turn refers to a 2002 judgment where Ackerman J also, made the same lamentation. And as I was reading those judgments, I was saying to myself, how many years later? Almost 18 years later. And the situation had, it was evident from the very case that we were doing that the situation had not changed much. So yes, I acknowledge that strides have been made to turn the situation around. However, we are not where we should be. And that is something that anybody who's driving around in the townships, who's driving around in the rural areas can readily see.
Thank you, Justice.
Thank
you,
you.
CJ.
Thank you. I've got two more hands before I go and see whether commissioners who are virtual have something. Commissioner Sepe.
Thank you, Acting CJ. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
Welcome.
Thank you.
I just wanted to find out from you, do you think the experience you have had in the specialist courts like the Labour Appeal Court and the Competition Appeal Court, whether that would stand you in good stead were you to be appointed to the Constitutional Court, given its extended jurisdiction that you've referred to already? Thank you.
Yes, thank you, Commissioner. Yes, most definitely. The experience I gained from acting at the Competition Appeal Court and from being involved in the Labour Appeal Court will help me a great deal. But in addition to that, I have obtained further experience as a justice of the Supreme Court, insofar as I have participated in other specialized, other matters, in specialized fields, like maritime law and intellectual property. I have benefited from the courses that were offered by the South African Judicial Education Institute. They offered an array of courses on an array of topics. And I also benefited from the training that was given by some of the judges of the Supreme Court of Appeal who have expertise in those areas. In other words, in addition to the training done by Sajay, Justice Wallis gave us training on maritime law at the Supreme Court of Appeal. I was privileged to be attending. And Judge Harms also gave us training on intellectual property. So all of that experience will stand me in good stead at the Constitutional Court. There's no doubt about it.
Thank you, Acting CJ. Thank you, Justice Molemela.
Thank you.
Thank you. Then I'll go to Commissioner Matolo Zepu and thereafter Commissioner Mpofu.
Thank you, Acting CJ. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
I'm looking at your CV and your qualifications, and I ask myself that where did you find the time? You've done so much to empower yourself. But having said that, I know through the struggles that we had whilst we were still in practice, that women were still underdogs. And they are still underdogs even now. As you say, we have a liberal constitution, everything is there. Having a bird's eye view of all in your journeys in all these courts, what do you think can be done? Because we cannot be underdogs forever.
Yes, there was a stage when Nadel invited me to speak on a particular topic. And that topic had to do with the challenges faced by young practitioners in the profession. And so I said to myself, I can't go and speak on that topic placing reliance only on my own experiences. I need to contact people to find out what's happening on the ground, because I'm no longer a practitioner, I'm a judge. And I contacted a number of people, and they too confirmed that is all the challenges that I faced are still extant. They are still facing the same challenges, despite some of the interventions that have been made. And I remember one of the things that they stated was that, look, we are being told that our senior colleagues will transfer skills to us. So we will also be involved in litigation that involves complex matters. However, we find that yes, we are roped in, we are involved, but there's no transfer of skills at all. And what they said was that we think that perhaps these people are afraid that once they have transferred the skill, they will become redundant. And so they are deliberately blocking. So, and those ladies were saying, we don't want to participate in a twinning setup where somebody is supposedly transferring skills to you, but what is actually happening is that you are accompanying this person, but there's no transfer of skills. You are not really involved in the issues. So I think to overcome that problem, the profession needs to do more than what it has done, because what it has done in the past has not solved the problem. The profession, and I think the department as well, will need to do more, because when I was inquiring from the departments, why are, for example, female practitioners not receiving enough support in terms of work? Because there's actually a lady from the Free State Bar who closed shop and said, I'm not getting any support. And then she stopped being at the bar. I think she's now an independent advocate, if I'm not mistaken. And, then she said, we are being told that sometimes when the instructions come to the state attorney's office, they go to the state attorney's office with a preference of which counsel to brief from the various departments. So it's not helping. Hence, I say, not only the profession must be involved, government must also be involved to see to it that there is indeed a transfer of skills. And you are not going to be able to pick it up to see that it is not happening unless you have a process where you are monitoring the situation, evaluating the situation. And then you have measures in place to say, if firm A or firm B does not comply, this is what we're going to do. We will not longer give them briefs from government. In addition to that, I think government will also have to assist in terms of the training of women. Be intentional about it to say, in addition to the twinning concept, women must actually be trained on those specific areas like maritime law, like mining law, and so forth and so forth. Women who are in practice maybe spend 3-4 months focusing only on that. But of course, government will have to come in terms of financing the project in the same way as government did when they were financing the project of fast tracking of women judges, which was a wonderful program in which I participated and I benefited immensely.
Thank you, Commissioner. Commissioner Mpofu.
Thank you very much. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
Yes, no, I just wanted to start by commending you on the issue of, let's call it independence. I had the experience of a matter where you found against us in an appeal, and then the same issue came before you, and you, in a dissenting judgment, stuck to the same principle that you had found before. I'm not mentioning the names of the parties because that matter is coming to the Concord very soon. Yeah, but I think that's one of the best attributes in a judge. I wanted to ask you about there's been a lot of emphasis on commercial, so-called commercial experience in the Constitutional Court. Just follow up on Commissioner Tsepe's question. In your case, clearly, having been in all the courts you've been to, your commercial experience, I think, speaks for itself. But my criticism with that, because with that analysis is because sometimes it's used to what is in modern language called subtweet. Is to subtweet black judges because they are assumed not to have this so-called commercial experience, whatever that means. In my view, law is law. Yeah. But do you find that the absence of that kind of obsession or maybe let's call it concern regarding criminal law experience, which is something that is closer to most people's experience with the law, and that criticism is sadly lacking? And my real question is then, what would be the importance, what criminal law experience do you have, and how do you think that stands you in good stead in the Constitutional Court, in as much as the commercial experience stands you in good stead?
Thank you. Yes, my career started as a prosecutor, so I gained a lot of experience from that. But then as a judge of the High Court, I had to do a lot of matters. It's a court where today you are in a criminal court, tomorrow you are in a road accident fund matter, the next day you are in a divorce matter, and so it goes. So I gained a lot of experience in that area of the law. I've done many appeals related to criminal matters at the Supreme Court of Appeal. And just in conclusion, I just want to give you the assurance that all areas of the law are equally important in my view. I mean, there's no way criminal law cannot be important when it is actually that area of the law that deprives the citizens of their freedom and sometimes for the rest of their lives.
Thank you very much. Thank you, Chair.
Thank you, Commissioner. Can I ask commissioners who are virtual whether they have any questions? There are no questions.
I'm sorry. I have a question.
Is that Commissioner Breitenbach?
Yes, Acting Chief Justice.
Oh, you have a question?
Please.
Yes, good. Please go ahead.
Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
What, in your view, is the single most important attribute of a Constitutional Court Justice, and why do you hold this view?
I think you said single most, so I'm thinking which one is okay. I think, without a doubt, judicial independence is the most important attribute. But I would add that you also need a thick skin.
Thank you very much. Thank you, Acting Chief Justice. I'm done.
Thank you, Commissioner.
Acting Chief Justice, it's Singh.
Yes, Commissioner Singh, please go ahead.
Yeah, thank you very much indeed, and good afternoon, Justice Molemela.
Good afternoon, Commissioner.
Just to quote what you said just now, you said all areas of the law are important to you, and that's very good to hear. Now, I also note from some documentation that you are working towards an LLD, the topic being the protection of the environment in terms of Section 24 of the Constitution. Are you still pursuing that? Just before I ask the question.
I'm not okay. Let me answer. I'm going to be maybe a bit long in my answer, but
could I then ask my question then?
No. Let me get to the point and say that I have changed the topic.
I must say, Acting Chief Justice and Justice, I am disappointed that you've changed the topic because, and I just want to ask you your views on the question of climate change and its impacts, internationally, nationally, and in African continent and South Africa. It's become a very, very, very serious problem. And I'd like to know, your view. Are we doing enough in practice and in law to mitigate the risks of climate change? Because we may have interviews, we may have buildings, we may have everything else, but one of these days we may not have earth to talk about. And there are big companies in our own country, and you know who those two are. State-owned enterprise is one of them, that are the biggest culprits when it comes to increasing carbon footprint. So what can the law do to help us in this? Thank you.
I think that is an area where there's going to be a need for as many non-governmental organizations as possible to be formed dealing with that area. In as far as my situation as a judge is concerned, there is not much that I can do because, as you know, Mr. Singh, the judiciary is reactive. In other words, the judiciary can only deal with the disputes that are brought to it. So in as much as when I sit and look around, I see many areas that need attention, they will have to be brought to the courts by the litigants. Hence, I say it's an area that will need the involvement of many people in the NGO sphere.
Yes, but it does not stop judges from expressing their views on the impact of climate change, and I hope that can be done because it's a very, very serious problem.
That's right.
You know, in our country and around the world.
Absolutely. When the right case comes, we'll definitely make the right judgment and give and be as elaborate as we can on the subject. But we have to wait for the right case.
Yeah, thank you very much, Chief Justice. I'm just suggesting that we don't have to wait. Even if there's no case, one can still publicly, as you talk to women, as you talk to everybody else, and activists, you know, express a view on the dangers and the risks of climate change. Thank you very much.
Thank you.
Thank you. Thank you. I think we have come to the end of this interview. Thank you very much, Justice Molemela.
Thank you, DCJ, and thank you, commissioners.
Thank you once again for availing yourself. You are now excused.
Thank you.
Thank you.